child. Because when it comes right down to it, the only way this community is ever going to get any better is if the children of tomorrow are raised properly. And the only way that's going to happen is if their interests are looked at. And that was the main reason why I'm running. That is one of the main reasons when I get in there, I want to implement some programs so that those children can be heard and our community can grow. Thank you.
Thank you. Mr. Jainer, do you want to go? Yes, go ahead.
My experience on the Community Corrections Board, and I mentioned it briefly in my opening argument or statement, is that we have a group that gets together, the sheriff and the police and the prosecutor and the judges. They're all welcome to attend. I wish it was better attended. But what we address is the problems that we're having in our community, especially as to confinement with our jail space. We have 239 beds, if I recall, that's the number. And we are full now, and we have been full for quite some time. I'm sure even Ms. Barnes can tell the times that Newt Jerome, who's the captain, will come through the hallway and say that I've got no room at the inn, or we need to let some out. So what we need to do is we need to look at alternatives. Mr. Gill mentioned it, expanding our treatment court from more than just alcohol to drugs so we can address that problem. All right. Also, what we have is we have pretrial services that's been implemented through this correction board. In a pretrial service, we have Matt Romeo that's serving that position right now. He's part-time. We really need him to be full-time. Why? Because he does risk assessments and helps us as judges determine whether this person's right for bond or not. We need that person. We talk about protection of our community. Judges would like that input instead of being there up on the bench, looking at the records and trying to almost guess at it and doing the best we can. But we have somebody that's now part-time because they don't want to pay him, but we need to make him full-time because he assists us in keeping who we need in jail and protected from, and those that we have that aren't as great a risk. Ladies and gentlemen, we are limited with jail space in our community, and our economy is not helping that out any better, and we're not expecting that to change. So what we need to do is we need to better utilize our jail for those that need to be in there, and for those that do not, that are at lower risk, we can at least have a better, allow our community to be safer. Thank you.
It's always interesting to answer the question fourth, because much of what's been said is very accurate. We have a jail space problem, and the way in which we get around a jail space problem is twofold. One way is to go through diversion programs, as many people have mentioned, and I have been a supporter from the beginning of diversion programs. I was on the team that created the treatment court that we now have. I went with Judge Alston throughout the country to form that court, and so I'm well aware of how diversion courts work, and that they do in fact work, that they save money, that they stop people from reoffending, and that's the big thing. If you've got an endless door where someone comes into the system, they get no opportunity whatsoever to change their path. You send them back out on the street, they come right back through the door, and that goes on forever. That cycle just goes on. I've been here, Mr. Jainer knows how long I've been here because we worked together when I first started here. I've been here for almost a decade now. And in that decade, I've seen 3 generations of the same family committing offenses. So I've seen the grandpa, the dad, and now the child. And that has to stop. And the only way that you stop that is by addressing the problems early. And you do that through diversion, but you also do that through listening very carefully and asking the right questions when you have them the first time in front of you. Because there's never going to be a better time to impact a person's life than that first time they're in jail. That's a scary moment. And when that first time in jail happens and you've got them in front of you in the orange jumpsuit, that is your moment to put them on a different path. And that has been a focus of my time on the bench. It will continue to be a focus as I continue in this job.
Thank you. Next question, I'll give you 2 minutes. I believe we're starting with Mr. Nichols. Kind of a question that maybe only an attorney would like to hear. Over 90% of the felonies that make it to a preliminary exam in this county are bound over to circuit court. First part of the question is, what is your definition of probable cause? The prosecutor at those hearings has to prove by probable cause that the crime may have been committed and that the defendant may have done it. So what is your definition of probable cause? And would you be in favor of a liberal or a more conservative application of the standard?
Definition of probable cause. Obviously, probable cause is, in my standard anyway. I mean, understand, first of all, I'm not a criminal lawyer. However, from the standpoint of probable cause, I would say it depends on what exactly is the factual situation in front of, and in this situation, I assume it's the police officer, what gives them the probable cause to search or do something that is necessary. It would arise to a level where there has to be that suspicion to allow them to do it. Am I more liberal or conservative with it? You know, once again, up in circuit court, we're dealing with felonies at that standard. However, when we're dealing with criminal nature, we need to look at the overall picture. I can't sit here and say I'll be more liberal or more conservative on something. It's going to depend on the factual situation. If I have somebody who comes in with several past felonies, is a habitual offender, abuser, does all kinds of different things that are, I mean, he's just not very productive in society, you're going to be a little more on the conservative side in dealing with those issues. When you deal with the individuals coming in and the standard, he's not a habitual, he has a family, he's dealing with other issues, you may want to be a little more on the liberal side. It's a factual question. Obviously, though, you want to side more, you don't want to put someone away who is innocent. You always want to sit back and take that look at it. I mean, our Constitution is in place. This country was founded on on a scenario that is important. However, we do have a community to protect. I have young children. There's a lot of young children. Everybody in this community is associated with people who probably have been involved in some sort of a crime or whatever. We do need to be strict on those areas. Thank you.
Mr. Blatter, do I understand the question is, what is the definition of probable cause in the context of a preliminary examination in district court?
Correct. What would your definition be? The second part being, would you be in favor of a liberal or a conservative approach to that standard?
The purpose of a preliminary examination in district court is simply to find out whether the state has evidence that, first of all, a crime has been committed, and secondly, whether there is evidence that the defendant committed it. It is not the time when they adjudicate whether or not the defendant is guilty or innocent. The definition isn't mine. The definition is set by the appellate lawyers, or by the appellate courts. Whether you're liberal or conservative on it is going to be, whether it's either going to be upheld or not by the appellate courts who have standards. I haven't researched that issue today, so I can't verbatim give you the definition that they have set. But the job of the district court judge when he or she conducts a preliminary exam is to basically answer that question. Has there been evidence of a crime committed, and has the defendant, is there evidence that the defendant committed it? It is, and to answer your question of whether that ought to be more liberal or not liberal, I think that's a matter of, if that's established, then you go to the circuit court and find out whether or not, when the case proceeds to trial, the evidence is credible enough for a jury to find beyond a reasonable doubt that there was, that the defendant is guilty.